Our next speaker is Laura Trapnell. Laura is the head of the firm's intellectual property team. I never quite know whether that means for the rest of us have no intellectual property, but anyhow. Laura handles non-contentious work relating to trademarks, patents, branding, designs, data protection, intellectual property and technology. She frequently advises clients in relation to their brand and brand protection and how to protect that in particular and protect their reputation. Laura is going to speak about managing and protecting a good reputation, in particular in relation to data protection. Laura.
Morning, thank you. I've actually had a really useful introduction to my talk from Stephen, so thank you for that. There's been a little bit of confusion about actually what I'm going to be talking about, because I think the assumption was that I would be talking to you about protecting your brand and public confidence in your brand, whereas actually I thought I was going to be talking to you about data protection legislation and the changes that are coming in with the introduction of the General Data Protection Regulation in 2018. I would love to be talking to you about your brand. It's what I normally speak about, and I can go on for hours, and it would be much more witty and insightful than the General Data Protection Regulation. But actually, I'm going to be talking to you about data protection. So I realise that data protection doesn't immediately set people's hearts aflame, as perhaps intellectual property does. But as Stephen has already pointed out quite clearly, it's an area of law that is coming under increasing scrutiny, particularly in the charitable sector, and particularly following the very tragic death of Olive Cook last year. Stephen's already mentioned the 2015 Etherington Review, which recommended that charities all exercise a much greater control over their direct marketing activities. So given that this is a conference on public confidence, and acknowledging perhaps that public confidence in the direct marketing activities of charities is currently not at an all-time high, I thought it would be pertinent to inform you of the quite significant changes that the GDPR is bringing in so that we can all start to prepare. So as I've said, I'm afraid there's nothing amusing at all in the GDPR. This intro is about as funny as it gets. So please be prepared. It's really bad. Please be prepared for about 20-25 minutes of really quite serious legal discussion. Hopefully it will be useful information, and I'm going to end up with trying to give you some active steps that you can undertake to tackle, I think, what is rapidly becoming quite an unworkable burden for a lot of smaller charities. So I'm going to be speaking about consent. Stephen's already flagged up the importance of obtaining consent, and I'm actually really interested to see that this is being filmed, because I'm not sure that I've given my consent to being filmed today. So I might actually start to exercise my data subject rights to not have this put on YouTube later, Hells. She's shaking her head, I can't do that. Okay. Oh, sorry, wrong way. That's because I've got it upside down. So it's taken 4 years for the text of the GDPR to be approved and agreed upon, and it was finally adopted in April earlier this year. It doesn't actually take effect until 2018, when on the 25th of May, it's going to replace the Data Protection Directive that we have all grown to know and love so much. So this gives us 18 months to start preparing for the changes. Refreshing ourselves of the key terms that are used in data protection legislation, the GDPR definition of personal data is very similar to the one that we all currently understand. So basically, personal data is any information relating to an identified or identifiable natural living person. So therefore, any data held on a person who has already been identified is personal data. And data held on any individual who can possibly be identified is also personal data. So this personal data that we're all used to is names and addresses, dates of birth, and that applies to your volunteers, your members of staff, and potential donors or existing donors. But it can also include more general information about physical, genetic, cultural, or social identity of a person. And remember, it can also apply to data which at the first instance might appear to be anonymised data, but on closer investigation can still identify somebody. So for example, the head of intellectual property at Paris Smith doesn't identify me by name, but if you type that into Google or type that into our firm's website, up I pop, photo and all, with my direct dial number, my email address, and all of that is then personal data which identifies me. So the GDPR retains the definitions that we're used to. The data controller is the legal entity that is in charge of the data that is being taken, in charge of who has access to it, what data it is, how long it's being stored for, and who processes it. That, in the terms of this seminar, is going to be the charity. The data processor is the legal entity that actually processes that data on behalf of the data controller. That's very frequently the same entity, but often, and particularly in the charitable sector, that sort of processing function is outsourced to a third party. And the data subject is the individual to whom the personal data relates, and that's very often the employee, the volunteer, or the actual donor. So data protection legislation bites on all areas of a charity's day-to-day activities where you are processing personal data. This includes the data relating to your employees, volunteers, donors, and also your website visitors. So data processed on these categories of people might be wider than you actually anticipate. So for example, if you have CCTV film cameras that are outside your buildings, protecting them from vandals, that CCTV film footage, if it's capturing people arriving at work and people can be identified from that data, then that is also personal data. It's data to do with computer logins. It's floor access data when you travel up in the lift every day to floor 2 of Paris Smith and swipe in. That is all personal data. It's cookie data on your websites. It's phone calls made and received by your charities. It's emails sent and received. It's bank details of donors, historical details of donations given in the past, and it goes on and on and on. So what's new? What does this GDPR bring in? When it comes into effect in May 2018, the GDPR is going to introduce some new changes. The first one is that there's going to be no more notification requirement. The current rules currently require data controllers to register with the ICO, and this is being abolished going forward. I think mainly because people aren't actually aware that they need to register, and the uptake on that has been significantly less than it's supposed to be. The scope of protection is also changing and is much wider than currently. So the new GDPR rules will extend to data controllers and processors who offer goods and services into the EU, but are themselves based outside of the EU. Now, that's not the case currently under the data protection legislation that we have, where charities are only bound by data protection law if they are based within the EU. So this wider ambit of the scope of protection means for us that even in a hard Brexit scenario, the new rules will probably still continue to affect us, particularly if you are processing data relating to any individuals who remain within the EU. So looking specifically at the new duties on data controllers, i.e. charities, under the GDPR, the main focus is going to be with regard to demonstrating compliance. Now, interestingly, listening to Stephen a moment ago, he's already mentioned the requirement for demonstrating compliance in regard to the fundraising regulator, and the GDPR is no different. We're all aware of our obligations as data controllers that we have to comply with the core data protection principles, And the GDPR is actually going to require you to demonstrate that compliance through documented decision-making processes and following documented procedures. So it will no longer be sufficient to be able to say, well, we're not in breach, therefore we must be compliant. You are actually going to have to demonstrate compliance actively, and this will probably require the implementation of new organisational measures. Another new thing coming in is that data controllers from May 2018 are going to have to embrace this new concept of data protection by design. So this means that data protection is going to have to be built in to your IT systems, subject to what is technically practicable and subject to cost. Thanks for that. Charities are going to have to need to build in safeguards to comply with the new rules. Those safeguards are going to have to include data minimization, ensuring that data is only processed for the specific purpose for which it was originally collected, and to ensure that data is retained for no longer than is strictly necessary in the circumstances. So this historic backlog and build-up of massive databases is not going to be permissible anymore going forward. The GDPR is going to introduce obligations on data controllers to undertake regular impact assessments of high-risk processing activities. How regular these impact assessments are going to be is currently unclear. We're waiting for more clarity on that. But it's anticipated that worst-case scenario means that it's going to have to be ongoing. But certainly we're going to have to look at it annually and go through high-risk data that you've got and make a strategic impact assessment. The detail required is going to depend on the size of your charity and the level of risk that's posed by your high-risk processing activities. But you certainly need to include a description of the high-risk processing activities, the purpose for which those activities are being carried out, and identify the potential risk from processing, and identify the measures that you are actively undertaking in order to minimise that risk. Data processors don't get away with it either, I'm afraid. Typically, charities tend to use data processors in a number of different contexts, including banking, outsourced HR, payroll, and sort of cloud-based service providers. The GDPR is going to tighten up quite significantly on the rules relating to the use of data processors, extending the formal contractual requirements that are needed between controllers and processors. So from May 2018, a third-party data processor is only going to be able to process personal data if it has documented written instructions from the data controller setting out the specific purpose for the processing activities to be undertaken. A data processor is going to have a new obligation to be aware of data breaches and to notify the data controller if it becomes aware of a data breach. Failure of doing that is going to incur a liability for the data processor. And so again, it's no longer permissible for a data controller to sit on their hands and say, we were just acting on instructions, we were just doing what we are told. The data processors are going to have to be accountable for their own actions, and they are going to be under an obligation to submit to audits and compliance to the controller directly. I think as a result of that, data processors are going to seek to limit that risk by wanting much greater clarity in their written documentation. And so I think engaging a processor for anything which is more than quite a simple task is going to become more complex. This slide's changed a bit, I'm afraid, because I'm talking a lot, I always do, and so I'm going to run out of time. So I'm going to talk about data subject rights and consent in a minute, and I'm not going to discuss it here. So under the existing law, data controllers are required to give individuals a privacy notice, a fair processing notice, which sets out what data is being collected, the purpose for which it's being processed, and any other further information that's required to ensure that the processing is fair and legal. Under the GDPR, there is a requirement for all that information to be clear, concise, transparent, easily accessible and in easy, plain language. So what that means in practice is that your lawyers will write your privacy notices and your HR person's going to have to go through them and make them more user-friendly. In addition, under the GDPR, data controllers will need to explain where the data has originated from, unless it has come from the data subject himself. They will need to explain who is going to receive the personal data, i.e. this is going to be transferred to an outsourced payroll. They're going to have to inform the data subject of the length for which the data is going to be stored. And charities are also going to have to inform individuals of the existence of their extended data subject rights. Where charities are going to be transferring data outside of the EU, remembering always that Brexit is coming, charities are going to have to provide individuals with information concerning the legal basis on which that transfer of data is going to happen, and also provide information on the safeguards that the data controller is applying to that transfer of data outside of the EU. So it's really quite apparent that data controllers are going to have to provide much more information than we do currently. And I think there's going to be a real a real level of tension between the amount of data and information that we're going to have to give people, and actually this requirement that we all have to be concise and clear and transparent, because the two don't marry up at the moment. But no doubt the ICO will be giving us reams of guidance on this in due course. Data subject access rights we're probably all quite familiar with, and the GDPR is going to take what's already under current legislation and keep it going forward. The GDPR is also bringing in a new package of rights, which is called Delete It, Freeze It, Correct It, which is going to include the right to be forgotten, which is a new right which has come in with regard to the Google Spain case, and is going to enable a data subject to exercise the right to be forgotten where, for example, the processing of data is no longer necessary in relation to the purposes for which that data was originally collected and processed. It's going to include the right of rectification where data is incomplete or inaccurate, and it's going to include a right for the data subject to restrict processing where the processing is either unlawful or where the data subject has objected to the processing based on the legitimate interest condition. I'm sure data subject access requests are the bane of everybody's life. The GDPR is going to actually introduce some fairly positive changes in regard to data subject access requests. Under current law, the response period for a data subject access request is 40 days. This is going to be replaced with an obligation to comply without undue delay, but within 1 month, taking into account the complexity of the request. So it's no longer going to be permissible for you to sit on a really small request or a really simple request until day 39 and then suddenly run around like a headless chicken trying to respond. The obligation is going to be to respond without undue delay, and your maximum period is going to be 1 month. Now, the GDPR is going to introduce a further 2 months response time if the request is particularly complex. Now, this need for compliance that is such a big focus going forward means that if you are going to take advantage of that additional 2 months, you have got to have gone through a really clear, transparent decision-making process to say, right, this request is incredibly complex. It's going to involve this person, that department, historical data. It's a complex request, and we are going to require the additional 2 months, and you must document that decision. The current £10 fee, which has never been sort of a justified representation of actually the cost of responding to these requests, the current £10 fee is going, and where a request is manifestly unfounded or excessive, a data controller is going to be entitled to charge a reasonable fee, taking into account the administrative costs in complying with that request. In addition to that, from May 2018, where a request is manifestly unfounded or excessive, a data controller is actually going to be able to refuse to act on the request at all. Now, this is a massive change, and it's not something that can be used lightly. the refuse to act on a request at all is going to require really clear and really justified reasoning, which must be fully documented. What comprises a manifestly excessive request is going to depend on the specific circumstances, and we're going to expect guidance on this in due course. But it is hoped that either the ability to charge a reasonable fee or the ability to refuse to act on the request at all is going to have the potential to discourage vexatious and onerous requests. That's the sort of impetus behind it. And what it's hoping will happen is that where a request comes in that is clearly excessive, there should be an open discussion between the data controller and the data subject as to actually what information it is that the data subject is after, and that there should be much greater transparency and dialogue. So the hope is that, if anything else, the new rules are going to inhibit requests encompassing thousands of emails requiring days and days of work from a team of people. Just touching on consent briefly, Stephen's already mentioned how important it is to actually have consent in a proper form. So the giving of consent is one of the legal gateways, and the least controversial legal gateway, through which a charity can establish the legal basis for processing personal data. As you might expect, the GDPR is going to set out stricter and more detailed conditions with regard to the obtaining of consent, and the onus will always be on the charity to prove that consent has been freely given, is specific, is informed consent, and is unambiguous. It will not be considered to have been freely given if there is no genuine free choice. I think at the moment charities tend to obtain consent for processing personal data by the use of standard provisions, either in an employment contract for their employees or contracts with volunteers if you have them, and also in terms of standard documentation like privacy policies. In general, these standard forms tend to be a take it or leave it, here it is, this is our privacy policy, and the individual actually has no real choice. So the ICO are already indicating that come May 2018, this way of obtaining consent stands a chance of being ineffective. The ICO is suggesting that where consent is given by means of a written declaration, the request must be made in a manner which is clearly distinguishable from other aspects of the document. And the ICO is really recommending that you use separate signature boxes for consent to be given. As is currently the case, the data subject has the absolute right to withdraw consent at any time. But the GDPR is going to make it an obligation on the data controller to make sure that the data subject is aware of that. So the reasoning behind that is that it should be as easy for the data subject to withdraw consent as it is for it to give it. Data protection officers. I think probably most of you have already appointed a data protection officer voluntarily. Under the GDPR, it's going to be compulsory if your core activities include systematic monitoring, large-scale processing of sensitive data, so health data, criminal records, that sort of thing, or if you are a public body. Data processors are also going to be required to appoint a data protection officer if the processing that they're carrying out is on behalf of a public authority or body. There are no set rules as to what the job description will be of a DPO, but just using common sense, and some of us solicitors have that, their main roles are going to be to advise data controllers and data processors of their legal obligations under the legislation, monitor compliance with the GDPR, be responsible for the implementation of policies, undertaking impact assessments, and embracing data protection by design. The idea is that they're also going to be a key point of contact for the regulator. It's intended that the DPO will be independent and have a role which in some ways is analogous to that of an auditor, but it is perfectly permissible for a DPO to be an employee. What else is new? There's going to be this new European Data Protection Board, which is going to be our source of wisdom and opinions and guidance as to how we're all supposed to be acting under the GDPR. I think given the impending Brexit, our much-loved ICO is going to continue to be our first port of call, but it will be useful for them to have this new board behind them ready to give us their wisdom with regard to data transfers in and out of the European Union. I'm actually not going to talk about binding corporate rules because I'm running out of time, but binding corporate rules are the sort of contractual way that charities, businesses with multiple international presences can share the data between them all. It has to be done under binding corporate rules. Data breach notifications. We all know that our employees and volunteers are the most wondrous of people. We couldn't run without them, but they can all make mistakes. We know that laptops get left on trains. We know that people send emails to the wrong recipients, .com instead of .co.uk, typos in names, etc. And we know that they're careless with passwords. All of these are personal data breaches. And under the revised rules of the GDPR, a data controller discovering a personal data breach must notify the regulator promptly and within a 72-hour time limit. If notification is not made within that time limit, then the data controller must provide a justified reason as to why the delay has happened. Now, please take on board that notification is not required where the breach is unlikely to result in a real risk to the data subject. For example, the laptop that I've just left on the train containing all of Paris Smith's contacts attending the charity forum today is luckily encrypted, so there's not going to be any real risk that anyone is going to get their hands on that data. Peter's breathing a sigh of relief. In notifying a breach, the charity must set out what has actually happened. It must set out the approximate numbers of the individuals likely to be affected and the likely consequences of the breach. You must also set out the measures that you are actively undertaking to minimise the fallout from the breach. And if there is a group of data subjects that are at a high risk from the breach, then you are now going to be under an obligation to notify them personally that the data breach has happened. Records of all data breaches must be kept, as you might imagine. And fines, just quickly. Current limits on fines that are imposed by the ICO are £500,000 in the UK. The GDPR is increasing this to €2 million or 4% of an undertaking's worldwide turnover if that is higher. Now, there should be, when I say that, sort of a collective intake of breath going around the room because that is a really significant increase. In practice, it might well be that the ICO actually continues to levy fines at the levels that they are currently using, but they now, or they will have from 2018, the ability to levy significantly higher penalties in respect of data breaches. So what should you do? I think the first one is not panic. What the GDPR is actually intending to do is to focus on what you are already probably doing, but there is going to be a greater focus on demonstrating compliance. Not just saying, as I said previously, we're not in breach, therefore we must be okay. We now have to actively demonstrate compliance. So start planning. We've got 18 months. It was 2 years when I wrote these slides previously. We've got 18 months, so let's start planning early. Active steps that you can take. We suggest genuinely consider appointing a data protection officer if you haven't already done so, and consider whether or not the appointment is going to be mandatory going forward. Review your privacy notices and your fair processing information, particularly with regard to the information that you give to your data subjects, and consider what additional information is going to be needed from May 2018. Review your contracts and your standard documents to see how consent is given, and establish a policy with a documented timeline for handling data breaches. make sure you obtain a full picture of exposure and undertake your impact assessments. And if all else fails and you have no idea what to do, come and seek advice. That's it. Thank you.